At a Senate Judiciary Committee hearing on July 30th, Senator Dick Durbin of Illinois pressed Trump Judicial nominee Joshua Dunlap, who was seeking confirmation to the First Circuit Court of Appeals on his views regarding abortion, including his past support for legislation that would impose additional barriers for minors seeking the procedure.
Mr. Dunlap, in March 2015, you submitted written testimony to the Maine legislature in support of a bill that would have made it more difficult for minors and incapacitated people to access abortion. The bill you supported sought to change Maine's law, which does not require minors to obtain consent of a parent or guardian before having an abortion. So let me ask you, today, should a minor who is sexually assaulted or a victim of incest be forced to give birth if her parents do not consent to her having an abortion?
The testimony that you are referencing would have brought Maine's laws into line with the laws of states such as Massachusetts and Rhode Island. It is also consistent with laws that the Supreme Court had upheld in Planned Parenthood versus Casey. My own views are not relevant to the job that I would have should I be confirmed to the U.S. Court of Appeals for the First Circuit. I would faithfully apply binding precedent as well as any laws that I was required to interpret.
So let me ask you, are you saying that what you said on in March of 2015 is the same position you hold today or a different one?
My personal policy preferences, again, Senator, are not relevant to the work that I would do. What I would seek to do is to fairly and impartially apply the law to every litigant who might come before me in a particular case or controversy.
And what about the precedent in Obergefell?
That would be binding precedent should I be confirmed.
For more congressional news, stay tuned to Congress Clips, and thanks for watching.